small
Supplementary is for orders item 1.
just one small on personal ground with respect to item 7. Actually, I have to appear before civil surgeon for my disability report which is to be submitted before MSCT court. I'm just paying for 2 days accommodation, my lord, in item 7.
Then it will be called out. Just put somebody. Mr. Banerjee, are you there? You are there for some time, no? Serial number 7 here.
Ji.
Please take care of his case.
Madam.
I will also remember, but an order has to be drawn.
By your serial number 20, I want to withdraw it. It has become infectious.
Serial number 20. Are you advocate on record?
Yes.
What's your name?
Either ready.
Item 20.
Writ petition.
Serial 20.
Serial
Case number,
20.
case number?
5443. 2023.
Second half है क्या?
कोई बात नहीं, second half order.
That to go manual.
Serial number 20 of second office. Right? The learned counsel for the petitioner seeks permission to withdraw this petition. Accordingly, this petition is dismissed.
Sign
Put your
करिए
signature.
सर, sign.
याद रखिएगा. Serial number 20.
From supplementary list for orders item 1, Penal Event 1152 of 2022.
Resolution number 1152 of 2022 with IA number 1815 of 2024. The learned counsel for the petitioner made this into a tricky application and filed seeking extension of time. With regard to removal of defects which has been granted by this court by order dated 8/2/2024. The time granted by the order dated 8/2/2024 is extended till 21st of March 2024. If the defects are removed within the said period, post is based on 22nd.
For case filing item 2, WPS 5590 of 2023.
This case, my lord, I inquired the matter. गाइड के अंदर ही नहीं आएगा.
नहीं आएगा.
नहीं, इसमें जजमेंट भी है.
Just इसका कंटेंट है. It was an order annexed along with the contempt application, which you have neither disclosed nor annexed along with the requisition. Right? WPS number 55. आपको देखना है पास ओवर कर रहे हैं?
मैडम,
आपको
नहीं
देखना
नहीं,
है
इसको
तो
पहले सप्लीमेंट्री में डाल.
No, supplementary name. That is not under challenge. That is not under challenge. Your case as comparison with MS Bhattacharya has been considered and rejected, which is not under challenge in this proceedings. WPS number 5590 of
इसको
2023.
जो
नहीं.
इसमें
No, we will not continue.
इनजस्टिस हो जाएगा.
We will just simply say that it is not there. We will simply say that it is not under challenge.
अंदर challenge by way of
Please,
IA.
no. You have suppressed this fact from this court. It is just a chance that these records are still available in the high court. Otherwise, it could have been destroyed by now. It is mentioned in the content disposal of contempt order itself. But you don't disclose it. And you want a fresh adjudication by this court. WPS number, Vijay record. WPS number 5550/2023. Posted petition has been filed for the following reason. Pursuant to order dated 22/2024.
My lord, with
Yeah, the
liberty,
council-
my lord, permit to withdraw this application with liberty to I will challenge the said order also, my lord. We-
Pursuant to order dated 22/2024, the council for the parties have jointly submitted that Central Administrative Tribunal does not have the necessary jurisdiction to consider the grievances of the petitioner, and accordingly the present petition is continued. This petition has been filed for the following reason. From the perusal of the petition, it appears that petitioner had moved this court earlier for the same relief in WPS number 4791 of 2009, which was disposed of by the order dated 15 September 2017 with the following directions. Para number 8, para number 7 and 8. At page number 49 and 50. This court also finds that a contempt application was filed by the petitioner in contempt case within bracket C number 86 of 2018, wherein following order was passed. From the perusal of the contempt order passed in the contempt case, it appears that two orders were annexed along with the show cause. One was order dated 18/11/2018, whereby the petition has been regularized, and another order was dated 3/8/2018. The petitioner has not annexed a copy of the order dated 3/8/2018 along with this writ petition, nor has mentioned anything about the same, and has deferred the present writ petition. The records of contempt case 86 of 2018 was called for, and upon perusal of the show was filed in the contempt petition. Wherein the case of the petitioner as compared with that of Krishna Bhattacharya was held to be not at par with that of Krishna Bhattacharya. In this petition, again the petitioner is claiming comparison with Krishna Bhattacharya, the order dated 3/8/2018, as annexed with the show cause in contempt case within bracket C 86 of 2018 is not under challenge in this present proceedings. At this stage, counsel for the petitioner seeks permission to withdraw this petition. This petition is dismissed as withdrawn.
With liberty to,
The petitioner may avail his remedy.
liberty में करने
That's it.
साइन कर लीजिए बस।
लेकर लेकर
अब सुने नहीं किससे, you will avail the remedy in accordance with law. That is sufficient.
साइन कर दीजिए।
This is gross sufficient. Yes, it is.
I never challenge any order, my lord. Can you see my prayer, my lord?
I see. Yes.
Matter 3, WPS 6204 of 2023.
साइन कर दीजिए।
Yes. Now you tell us, is it your case that you are covered under the scheme or you are not covered under
I am covered under this scheme.
Now let us see the impugned order. This is number 82.
Yes. I am permitted to file this rules and 2019 amendment. Yes.
Madam.
Page.
Page 82. These were the documents which you had annexed.
No, I was not given an opportunity of being heard before that
No,
committee.
not, but these documents you annexed, isn't it?
Yes, I have annexed this. This is part of interim order.
So these were the documents which you had annexed before that.
No, I have not filed. The department must have forwarded my documents. The DFO must have forwarded these documents to the committee. I was not given any opportunity of being heard. I was not
So
present.
hearing is one thing, but you
No,
must have
no.
came pursuant to the order of this court.
No, I was never called before that committee.
You see, Manviya Jharkhand, what is your name?
Sayyid Naseem Akhtar.
And Ramashri.
There was a contempt petition filed.
Madam.
And therefore this order was passed.
Yes, madam.
And you see that you were never called.
No, I was present in the court. I am the.
In contempt case, where is, you must have moved this court earlier?
This
Where
is
is that order?
fifth time I have come before this order.
Where is the last order which was arising out of
That is Annexure 17.
annexes?
No, that is not the last order. Contempt was decided. Lastly, they have passed some order. You may prefer fresh writ petition.
Where is the order of the
And
writ?
one order was passed. That
Where
is
is the order of the writ?
writ court. That is Annexure. Page 62, Annexure 14. And 14 by 1. Page 63.
Annexure 14. Page number 62.
2.
This is Ramesh Mehta's petition number 2.
No,
madam.
Page 62, Annexure 14 is Sayyid Naseem Akhtar and another. And page 63 is Ramesh Mehta.
Okay. Naseem, this was the writ petition you had filed.
Ji.
WCS
4954
4942 of 2001. It was disposed of in terms of WPS number 5924 of 2003, dated
31/7/2012.
31/7/2012.
That order is Annexure.
These were the orders which were prior to
Framing of rules.
framing.
Yes.
Now let us see the content of the order passed in WPS number 594.
This Honorable Court directed to frame rules
Where
within
is
one.
that?
It starts from 63 and relevant part is at 67.
So the case of Uma Devi must have been referred.
Yes.
And since there was no rules framed, so there was a direction to frame the rules, right?
Right.
And the competent authority shall examine the case strictly in accordance with the rules.
Yes. Yes.
So therefore, in your case also this order was passed, therefore the competent authority was bound to consider your case. Right? Now you file contempt petition.
Yeah.
Where is the order in the contempt petition?
Final order is not annexed. Interim order is annexed.
Where is the order?
That order starts from page 672. 73. Annexure 70.
This contempt petition was filed by both of you,
Yes.
right?
Yes.
So they were facing contempt for non-compliance of the order.
They were
And
directed to
during
be.
the pendency of the contempt case, they passed the impugned order.
Yes.
In the impugned order, they were considering your case for regularization
Regularization.
under the 2015 scheme. So under the 2015 scheme, you come to Rule 3. I think this is the main thing. Rule 2 Roman 2 and Rule 3.
Rule 3, they have
Rule
referred
2
to
Roman 2
Rule 3.
and Rule 3 also. Both of them.
Rule 2 अनियमित नियुक्ति। अनियमित नियुक्ति से तात्पर्य यथोचित प्रक्रिया अपनाए बिना प्राधिकार द्वारा की गई नियुक्ति जिसमें अवैध नियुक्ति शामिल नहीं है, अर्थात उक्त नियुक्ति स्वीकृत पद के विरुद्ध की गई हो एवं कर्मी उक्त पद के लिए निर्धारित शैक्षणिक योग्यता धारित करते हो, किंतु चयन में खुली प्रतिस्पर्धा का रास्ता नहीं अपनाया गया।
So first is your appointment should be against sanctioned vacant post.
And I must have requisite qualification.
You should have the requisite qualification, but the process of selection might not happen. Now,
I have annexed Annexure 17 its interim order because this honorable court had that this is the case.
You just we'll come to that. Rule 3.
Yes.
Read it, please.
Rule 3 का सेवा नियमितीकरण. Now they have quoted का 3 and का 9. उक्त नियुक्तियां सक्षम प्राधिकार के द्वारा की गई हैं. First का 3 and next is का 9.
Do you satisfy Roman 3?
Yes, I do.
So let us see petitioner number 1. Who
Yes.
appointed and whether he was a competent.
All right.
Who appointed petitioner?
Your Lordship may see para 1 of my writ petition.
Show me the document and state of
The document I may be permitted.
Where is your appointment letter? Your appointment letter?
Annexure 1 may be seen.
Petitioner 1 number 1. What is his name?
Sayyid Nasir
Sayyid
Afzal.
Akhtar. Date of appointment?
Date of appointment is actually 10 January 1985.
10/1/1980. Appointment letter?
This appointment letter is not with me.
Not-
Subsequently,
Not able, just
yes. Subsequently, I was appointed on a sanctioned and vacant post.
This is the original appointment.
Original
There is a
appointment
question of
was
subsequent appointment.
fresh appointment was made. That is Annexure 1.
Date.
Date is 28/3/1987. After 2 years. That
This
is
is the regular appointment.
नहीं, regular नहीं. It is irregular appointment because it was not open competition.
Irregular
But-
appointment. Just a moment. On the post of
दैनिक वेतन भोगी टंकक को लिपिक के रिक्त पद के विरुद्ध
on daily wage.
yes on daily
Daily wage. Lipic is
clerk
Any pay scale given?
नहीं daily wage
Daily.
28/3/1987 this is Annexure 1 page 30.
Who appointed?
One Sarakshak, conservator of forest. Your Ladyship may say para 4 of my writ petition.
What have you stated?
Petitioner number 1 is continuously working since 10th January 1985 in the Social Forestry Division Garhwa as clerk cum typist on daily wage basis and is still working. There has been no break in his service. The petitioner number 1 was allowed to work on vacant section post white order dated 28/3/1987. Experience certificates were also issued on it 9.
Let us see annexure 1.
One Pramandal पदाधिकारी सामाजिक वानिकी प्रमंडल गढ़वा, सामाजिक वानिकी प्रमंडल सोशल फॉरेस्ट्री डिवीजन गढ़वा द्वारा मौखिक रूप से की गई अनुशंसा के आलोक में श्री सैयद नसीम अख्तर दैनिक वेतन भोगी टंकक को लिपिक के रिक्त पद के विरुद्ध हिंदी एवं अंग्रेजी टंकक का कार्य करने की अनुमति प्रदान की जाती है।
वन प्रबंधक पदाधिकारी यानी कि
डिविजनल नहीं, डिविजनल फॉरेस्ट ऑफिसर,
डिविजन।
हाँ, एंड सिग्नेचर इज ऑफ वन संरक्षक इज कंजर्वेटर ऑफ फॉरेस्ट।
यहाँ वर्ड है मौखिक रूप से।
This is on oral instruction,
माइनर
right?
Subsequently, your ladyship में से annexer 1 by 1. This is of 39.
So these are all experience certificates.
No, it is relevant. That's why. Your ladyship may come to page 36, annexer 3. 6, annexer 3. सेवा में वन संरक्षक, राजकीय व्यापार अंचल, स्टेट ट्रेडिंग डिवीजन, पलामू 2.
What do you want to say?
Yes. इसमें लिखा है लिपिक, वैकेंसी पोजीशन दिया है, अभियुक्ति राइट साइड में लिखा हुआ है, अभियुक्ति क्रम संख्या 1, इस पद के विरुद्ध दैनिक मजदूरी पर श्री सैयद नसीम अख्तर कार्य कर रहे हैं। इनका आवेदन साक्षात्कार हेतु इस कार्यालय के पत्रांक दिनांक 13/3/91 द्वारा आपके कार्यालय में भेजा जा चुका है। अतः अनुरोध है कि तृतीय एवं चतुर्वर्ग के पद पर नियुक्ति के संबंध में आवश्यक एवं त्वरित कार्रवाई करने की कृपा की जाए। वन प्रमंडल पदाधिकारी, डिविजनल फॉरेस्ट ऑफिसर इज राइटिंग टू द अपॉइंटिंग अथॉरिटी, वन संरक्षक, कंजर्वेटर ऑफ फॉरेस्ट। ये इसमें रिकमेंडेशन था। Similar.
When you attended the interview?
No, it was not called. Repeated recommendations were made by divisional forest officer continuously. That is what I am trying to show. Then there is another annexer 3 by 1. Similar है कि ये इस पद के विरुद्ध श्री सैयद नसीम अख्तर कार्य कर रहे हैं, 92 का है. Then again annexer 4 में भी seen 93 का है.
So there is a vacancy position shown and you have been asked to participate in the interview. It is not any selection process.
नहीं, selection process नहीं है, लेकिन subsequently specific recommendations were
The
made.
recommendation एक individual का कैसे होगा?
नहीं, और भी था. I will come to that point. Your Lordship may see my para 20, 21, 22, etc. Similarly situated other persons have been regularized, more than 20. And I have specifically
When
stated.
they were regularized?
Yes,
What is the date?
Yes,
What is
that-
the name of those persons?
yes, name has also been,
What is the
order
name?
is also annexed.
When they were regularized?
I have given that
What is the date of their regularization?
they were given in regular pay scale, they were appointed in 1987 itself. When
So they were appointed in regular phase.
no, they were appointed like me, similarly situated. Later
When
on,
they were regularized? When were they regularized?
your ladyship may permit to read para 2021 of the writ petition. That it is submitted as services of similarly situated employees, namely Pradeep Kumar Mishra, Dinesh Prasad Yadav, has been regular appointments on their post by office order dated 5/12/87 and order dated 30/12/1987. Copies annexed.
Para number?
20, 20.
They were regularized in 1987. They have nothing to do with the present.
They have to do, my lord, because in 2001 writ petition, I made similar submission that similarly situated employees has been regularized.
2001 writ petition was prior to coming into force at this particular scene.
just
Any person who has been left out from regularization prior to coming into force of this scheme cannot claim the benefit of similarly situated person. The scheme does not say that any person who is similarly situated prior to coming into force of
I may be
the
permitted
scheme.
to subsequent paragraphs because they responded on my submission in the 2001 writ petition. What was
We
this?
will not go by this. Are you entitled for consideration? Your claim for regularization was not allowed in the writ petition. What was allowed was that they have to frame a scheme.
Huh.
And therefore, your claim for regularization was to be considered against a scheme.
Excuse me.
Now you cannot say that some persons were regularized prior to coming into force.
No, what was their response? I quoted that
The
correctly.
response will not go. What is the direction of it? We will go by the
No.
direction of it.
For what reason it was not considered?
Please don't. You see, you cannot reopen things like that. If the state has to take a policy that those persons similarly situated were regularized prior, then also you will be entitled for something more. That is a separate thing. There is already an order passed by this court directing the state to take policy decision in this, right? We cannot prejudge an issue like this. No, we can't do it.
And I have given separate names other than these two petitioners whose order I have annexed. Other persons also, more than 20% has been regularized.
Prior to coming into force of this circular or after coming into force?
Prior. Those
You
were
cannot
regularized
compare.
prior. What?
You just cannot compare.
Achha. ठीक.
That is all so far as the petition number 1 is concerned.
No, not all. Okay.
Firstly, you see, I just don't understand. Two petitioners have distinct cause of action. And you mix both of them in one writ petition.
Your ladyship may see this annex 16 and page 72.
Yes.
Both cases were
Maybe both cases were tagged, but they have a distinct cause of action, different timelines, different facts. I just don't understand. That creates a lot of problem in understanding the facts of the case.
they have rejected my regularization
On
on
the
two grounds.
ground of clause 3 point,
Ka 3 and Ka 9.
clause 3 and clause. Petition number 1.
Yes.
Clause 3(1).
3 Ka 3.
3 का 3 और एक 3 का 9
3 and 9.
9 उक्त नियुक्तियां सक्षम प्राधिकार के द्वारा की गई, इनका नहीं हुआ है।
उक्त पैरा 9 यह नियम उन पदों पर
रोमन 3 में
रोमन 3
एंड 9
यह नियम
उन पदों पर नियुक्तियों के लिए लागू नहीं होगा जिन पदों पर नियुक्ति के आयोग चयन।
Yes. My submission is at that time there was no staff selection commission in Bihar. It came into force in 2002.
Who was the competent authority?
Yes.
It
Repeated.
came into force in 2002.
Appointment of third appointment. Yes. Copy of rules. 3.31 appointments. Appointments of the assistant in the chief conservator cadre and circle cadre will be made by the chief conservator of forest Bihar in scale of lower division assistant who have passed the lower division examination held by finance department. No lower division assistant will be appointed in upper division unless appointing authority was conservator of forest. This is my submission.
Conservator of forest gave oral instructions.
No, oral instruction was given by divisional forest officer. Appointment was in writing by the conservator of forest.
Okay, so you
Appointment.
are governed by this rule?
Yes, I am governed by this.
Can you read it once again? Can you read it once again?
Appointment of assistants in the chief conservator's cadre and circle cadre will be made by the chief conservator of forest Bihar in the scale of lower division assistants who have passed the lower division examination held by Finance Department, subsequent parties, this was, and my
No, it is talking about some examination.
examination, yes, it was not open competition. That part is irregular appointment. If it has not come through.
There has to be some examination to be conducted.
Yes, examination was to be conducted. But if no examination was conducted, I was irregularly appointed. This will come within the purview of irregular appointments. Open competition. This was held in ML Kesri case.
And the appointment of stenographers and typists will be made by the chief conservator for his office from amongst the past stenographers and typists of the finance department. So you were not qualified. On the date of appointment, you were not qualified because you did not pass any examination.
My qualification has already been dealt in Annexure 17 by this Honorable Court. It has been considered that I was duly qualified and this appointment was irregular. For a moment, if your Lordship may say this.
Is there any finding of this court that this appointment was irregular?
I may be permitted to read this page 80, 77 and 80, 78. Page 77, from para 80. The judgment passed by Honorable Apex Court regarding distinction made by irregular and illegal one has again been deliberated by the Honorable Apex Court in the state of Karnataka and others versus ML Kesri and others. This court, on the basis of ratio laid down by Honorable Apex Court and coming to the decision taken by the committee is of the prima facie view when opposite party themselves scrutinizing the case of the petitioner has come to the conclusion on the basis of report given by the competent that appointment of petitioner number 1 was made against sanctioned post as on 28/3/1987 and also having due qualification since the conscious finding has been recorded. The said petitioner number has passed intermediate examination in the year 1981, which was the required educational qualification to hold the post. The other ground of his continuation of 10 years of service having not been followed in terms of judgment by the Honorable Apex Court in Uma Devi case, the same will be said to be under the fold of irregular appointment. Likewise, also the case of Ramashra Yadav, wherein it appears that his case has been rejected in a very cryptic and mechanical manner and on the ground that petitioner number 2 Ramashra has failed to produce the relevant records about sanctioned post having been created. The issue of post created is not under the domain of appointing authority. As such, it was the duty of appointing authority to assess the fact that on the basis of documents available, but having not done so, rather the petitioner has been blamed that no document to that effect has been produced. It further appears that it cannot be said that Ramashra Yadav petition number 2 was having no educational qualifications since it finds at column 3 under the discussion made with respect to the case of Ramashra Yadav that matriculation was the qualification which he had passed in the year 1980 while he was appointed on 28/6/1986. Therefore, this court is not in agreement with the submission advanced on behalf of learned counsel for the opposite party that the instant contempt is required to be dropped considering the decision taken by the committee on 11/1/1923 to be non-compliance of the order passed by the writ court. This court further is of the view that on the basis of decision made here and over, since the said decision 11/1/23 cannot be said to be in consonance with the judgment of the Honorable Apex Court rendered in Honorable Supreme Court in Uma Devi case, same cannot be said to be compliance of the order of this writ court. This court therefore is of the view that presence of commissioner is required to explain as to how judgment passed Honorable Apex Court in Uma Devi case has been interpreted and is further directed to explain as to why a proceeding be not initiated for non-compliance of order passed by commissioner is required to be present.
There was an earlier decision taken 11/1/23.
Yes,
Where is that?
that is referred in this impugned order.
Where is that?
Since that has been set aside by
It
them,
wasn't
they
set aside by
themselves,
this court.
no, by themselves, they have reviewed and passed the impugned order.
Where is that?
That part, relevant part is quoted in Annexure 18.
You do not annex the relevant documents also.
Since that has already been reviewed and set aside by themselves.
Where is it reviewed and set aside? This court never set
No,
it aside.
This is referred in Annexure 18. Another 18 start from page 79.
So according to you, your appointment is by the competent authority, right? In view of this particular rule.
In view of this particular rules. And
Has
secondly,
it- you have been appointed by the
conservator of forest.
by the conservator.
Subsequently, recommendation was made to chief conservator of forest as well. That order,
Recommendation, but your appointment was by conservator of forest.
recommendation was divisional forest officer by division. That order, that letter also I have annexed with this writ petition.
Recommendation.
And they have themselves considered that this is a case of irregular appointment. Leadership is another 15, page 68.
Page 68.
I have completed 39 years of service. And due to विषय ऊपर ही लिखा हुआ है, अनियमित रूप से नियुक्त एवं कार्यरत कर्मियों की सेवा नियमितीकरण से संबंधित प्रतिवेदन उपलब्ध कराने के संबंध में अनियमित, they are themselves saying that these two petitioners are aniyamit, irregular appointment.
Irregular, not illegal.
Yes, that is my submission. Irregular appointment. This is case of irregular appointment. और उसके बाद इन्होंने सारे डॉक्यूमेंट्स हमारे फॉरवर्ड किए. I was never called before this appointment selection committee or regularization committee. The DFO has sent my documents, whatever they have considered, and thereafter this thinking order has been followed. Annexure 16 may also be seen, page 70.
Just the learned counsel for the petition with respect to the petition number 1. Let me record your submissions with respect to petition number 1. Has this is a part of this document. You just
No, this is not part. This is regularization rules. This is part of regularization rules.
regularization also.
Forest Department.
3.31. Where is the rest of the? Where is the complete text? Forest Department had its own regularization rules.
Forest rules. Forest rules. Heading is forest rules.
Which rule is this?
3.31.
The learned counsel for the petitioner has submitted that. So far as the petition number 1 is concerned, we have moved this court earlier in WPS number 4942 of 2001, which was disposed of by the order dated 29/2012 in terms of order dated 31/7/2012 passed in WPS number 5924 of 2003. In the said case, the petitioner was seeking regularization. So far as WPS number 5924 of 2003 is concerned, it was disposed of by the order dated 31/7/2012. The same was disposed of by taking into consideration the submission made by the learned advocate Delhi that he was right in submitting that after the enactment of the scheme for regularization, competent authority shall examine as to whether particular employee was given appointment strictly following the procedure of public employment, had the requisite qualification for the post, and was given appointment against the existing sanctioned vacancy, and appointment was made by the competent officer. The learned counsel submits that subsequently the scheme for regularization was framed by the respondents by notification dated 13 February 2015, and certain modification was done by notification dated 26/2019, and the respondents have And in the meantime, the petitioner had filed a petition for contempt, with contempt within bracket civil bracket close 681 of 2021, and in which an order dated 17 February 2023 was passed, and he submits that as per the report of the respondents, the petitioner has been working against sanctioned vacant post, and the appointment of the petitioner was irregular and not illegal. The learned counsel has referred to the rule governing the petitioner being ruled and submit that the appointment of the petitioner was at the relevant point of time was covered by Rule 3.31, which is quoted as on. The learned counsel submits that by the improved order, a decision has been taken on the basis of the documents forwarded by the Forest Department, and as per the same decision, the petitioner was not qualified for regularization on account of the allegation that the appointment was not made initially by the competent authority, and further the appointment in connection with the post was to be made through the Jharkhand selection
Staff Selection Commission.
by the staff selection commission. The learned counsel submits that at the relevant point of time when the petitioner was appointed, in view of the aforesaid rules, the appointment was not required to be made by the staff selection.
नहीं, that was not in
ये
force.
चीज तो आया है
Just a
नहीं,
moment. आपको सुनेंगे, रुक जाइए.
मैडम।
The appointment was not the appointment for this post was not required to be made by the staff selection commission.
नहीं, it was required. It was not in force. It was not constituted at that time
No,
in Bihar.
as per the rules, there is nothing. Staff
Yes.
selection commission not mentioned.
Yes.
The learned counsel submits that had these aspects of the matter had an opportunity of hearing was granted to the petitioner, these aspects of the matter could have been brought to the notice of the authority, and they could have taken that into consideration for the purposes of the claim of the petitioner for regularization. And accordingly, he submits that the impugn order is to be set aside, and the matter may be remitted back for fresh consideration, so that the petitioner may be heard. Petition number 2 for counsel. So far as petition number 2,
Petition number 2 was appointed on vacant post of peon.
where is the appointment letter?
Appointment letter is not with. Appointment
When?
letter.
What is the date of appointment?
Para 5/6/7/1985.
Appointed,
Yes.
right? You don't have any appointment letter?
No, I don't.
Any document?
Document, several documents, sir.
What document?
You ready to see Annexure 2 series.
According to you, who appointed you?
It was made by Divisional Forest Officer.
Para number? Para number?
Para number is not mentioned.
No, in which paragraph are you? That the division for forest officer.
Divisional Forest Officer is not mentioned. Later subsequently it has come in the orders.
Which order?
Uh,
Show me your documents with regard to petition number 2.
Annexure 2, page 33.
Election 2, page number
33.
33. Yes.
प्रमाणित किया जाता है कि श्री रामाश्रय यादव पिता श्री इतना औरंगाबाद के रहने वाले हैं, सामाजिक वानिकी प्रमंडल गढ़वा में जुलाई 1985 से कार्यरत हैं। इनका कार्य संतोषजनक है।
The appointing authority is not mentioned.
appointing authorities now mentioned. In page 35, similar. Issued
So
by
you are not aware as to who appointed you. But you have been working.
working and retired.
When did you attend the age of superannuation?
It was 30th June 2022.
36, 2000.
These say
You attained the age of superannuation. And what about petitioner number 1? He is also
he is working. He is still working. He is due to retire on 30th June this year. Petition number 1.
What was his age at the time of appointment?
Must have been around 20 years. 21. Petition number 1.
In the year 1985.
80.
So he has attained the age of superannuation, but is he receiving any post-retirement benefits? Nothing.
No, he was on daily wages.
He was on daily basis.
Daily wages. Both the petition, daily wages.
No DPF, nothing.
No.
DAPF, nothing.
Yes.
What else? So far as petitioner number 2 is concerned.
Then annexure 5, page 39 and 40.
But so far as Ramashra Yadav is concerned, the earliest letter of appointment
That
is
is
dated 28/6/1996.
96. The letter was issued, but the certificates are continuously from 6/7/1985.
There is that 96 letter.
96 letter, since they had mentioned in the 83 order, therefore that is quoted. But your
Where is
leadership
the
is
96 letter? You have not annexed?
he was class 4 employee. He don't have any documents. These documents were given by some of the staffs to him. His annexure 5 may be seen, page 39 and 40.
Annexure 7. Page number 46. This is the covering letter of that list.
Next page is 47, column number 2, रामाश्रय यादव किस तिथि से कार्यरत हैं? 6/7/1985. कार्यरत की तिथि से डाक पियून का कार्य आदेश पद के विरुद्ध किया जाता है. Bonus were also paid to them. Different kinds of their transfer was also made to them.
Alright. And then what else? What is the reason for rejection of petitioner number 2?
It has come. Alright, this is
Clause number.
clause number is 3 third, Roman 3rd.
Not appointed by the competent.
Competent. इनकी सेवा के संबंध में भी सक्षम पदाधिकारी द्वारा
Has it come in the use order as to who had appointed him?
इसमें क्लियर कट है कि इनका जो है सक्षम पदाधिकारी नियुक्ति पत्र निर्गत नहीं किया गया है एवं इनकी सेवा में चयन के समय में किसी भी चयन प्रक्रिया का अनुपालन नहीं किया गया है. जहाँ तक सैयद नसीम अख्तर की सेवा का प्रश्न है, तत्समय सक्षम प्राधिकार द्वारा इन्हें कोई नियुक्ति आदेश निर्गत नहीं किया गया था, बल्कि वन प्रमंडल पदाधिकारी सामाजिक वानिकी प्रमंडल गढ़वा के द्वारा मौखिक रूप से की गई अनुशंसा के आलोक में कार्य करने हेतु दैनिक मजदूरी पर रखा गया था. इस प्रकार श्री
So
सैयद
your
नसीम
case also will be covered by this rule? No. You?
वो जो रूल दिखा रहे हैं वो जो एप्लीकेबल नहीं है,
टंकक के लिए
क्योंकि उस समय
लिपिक के लिए।
क्लियर कट ये जो है ये ऑर्डर जो पास किया गया है मिनट्स ऑफ मीटिंग हेडेड बाय द कमिश्नर मैडम, इट इज क्लियरली कि वो जो है ये अतः इस यहाँ हम पढ़ रहे हैं 87 पेज 87 का रिलेवेंट पारा है. जो स्टाफ सिलेक्शन कमीशन की बातें कर रहे हैं वही
You
इसमें
see, if the selection process is not followed, here
No.
also the staff selection process will not come because he has been working since 1980.
नहीं, हम तो कह रहे हैं कि था, ये आया हुआ है पेज 87। अतः इस मामले में मैं रीड योर
Yes.
अतः इस मामले में झारखंड सरकार के अधीनस्थ अनियमित रूप से नियुक्ति एवं कार्यरत कर्मियों की सेवा नियमितीकरण के नियमावली 2015 के कंडिका संख्या 3 का 3 का उल्लंघन हुआ है। साथ ही सैयद नसीम अख्तर के लिपिक सह टंकक की सेवा में रखे जाने के समय उस पद पर नियुक्ति के लिए आयोग चयन प्राधिकार बिहार लोक सेवा आयोग कार्यरत था। ये कह रहे हैं कि कार्यरत नहीं था।
नियुक्ति के समय you are taking his date of appointment of the year 1996, but he was working since 1985 as per your own document.
अब वो तो है, बट ये उस समय
You
तो
have to see when, as to where he was working in 1985. You have to see his status in the of the year 1985. You have taken his date of appointment as 1996, which is not correct. Because the enclosure to that letter is itself indicating that he has been working since 1985. Page number 47. Page 47. This is the enclosure to this. And your document. Isn't it? It is your document. Right?
मैडम
So therefore you see, you give them an opportunity. This is an ex parte offer. They have been working since 1985. So the documents are enough to show that they have been working since 1985. You pass an order. They say that at
But
that point in
appointment
time.
of the petitioners are not a regular matter,
Why did you
illegal.
consider it? Why?
मौखिक रूप से
You
किसी
have
को
yourself given a report that it is an irregular transit. You have not given a report that it is an illegal transit.
बट ये तो क्लियर कट है लेक्चर
So
1
therefore,
जो
your authority has to look into it. So far as the petitioner number 2 is concerned, the learned counsel for the petitioner has stated that the petitioner has been working since 6/7/1985 against the sanctioned post of peon. Adeshpal ko यहाँ पर?
Pure.
प्यून
Against the sanctioned post of peon, which is apparent from the document enclosure to the letter number 454 dated 28/6/1996, and therefore the date of appointment of the petitioner cannot be taken as 28/6/1996. Rather, it could relate back to 6/7/1985. The learned counsel further submits that the at that point of time, so the selection process which was prevalent at that relevant point of time is required to be taken into consideration. And consequently, the matter requires fresh consideration. The learned counsel submits that if an opportunity of hearing was granted to the petitioner number 2 also, then these aspects of the matter would have been brought to the notice of the respondent number.
Commissioner, Regularization Committee Chairman.
To the respondent number. Respondent number 5, the learned counsel further submits that as per the report of the respondents, the appointment of the petitioner number 2 was also irregular and not illegal. Is that correct? The counsel for the respondents has submitted that every aspect of the matter has been taken care of.
विदाउट फाइलिंग
No contract date has been filed in the present case. However, on the face, the learned counsel for the respondents on the face of the impugn order has submitted that every aspect of the matter has been taken care of, and the documents which were available with the department has been duly verified, and However, from the perusal of the impugned order as contained in memo number 261 dated 14/3/2023, it is apparent that no opportunity of hearing as such has been granted to the petitioner. After hearing the petitioner for a considerable length, this court is of the considered view that many aspects of the matter which the petitioner is arguing before this court is required to be taken into consideration, and had an opportunity of hearing been granted to the petitioner, the same would have been brought to the notice of the authority for consideration. It cannot be disputed that the petitioner would be entitled for regularization only if the petitioner falls in the scheme framed for regularization of the year 2015 read with the scheme of the year 2019 or any or the year 2019, which are the applicable rules of regularization as on date. Considering the aforesaid aspects of the matter, which has been argued by the petitioner, this court is of the view that at this stage, even without calling for a counter affidavit, the impugned order is required to be set aside in as much as it appears from the impugned order itself, no opportunity of hearing was granted, which has very serious impact upon the petitioners who claim to be working since the year 1985/87. Accordingly, the impugned order contained in memo number 261 dated 14/3/2023 is hereby set aside, and the matter is remitted back to the respondent number 5 for fresh consideration in accordance with law. The petitioner is, after granting an opportunity of hearing to the petitioner, the petitioners shall file their detailed representation with all supporting documents along with a copy of the written record before the respondent number 5 within a period of 15 days from today.
Yes.
Within a period of 15 days from today, and thereafter the respondent number 5 shall give an opportunity of hearing to the petitioner. The petitioner may also, both the petitioners may also file their written submissions before the authority for consideration. The recent order will pass within a period of 6 weeks from the date of the presentation and be communicated to the petitioners.
I may be exempted from filing certified copy. He may waive this.
Certified copy means?
Web copy file कर देंगे. Certified copy it may take some time. Certified copy of your lordship.
Accompanied with a web copy of this. ये लेकिन ना, this is not proper. किसी का एक पेज आप ऐसे देते
जी जी. अभी just now
the full text of the rules which are being, or the forest rules which are being relied upon by the petitioner, whose rule 3.31 has been quoted in the submissions of the petitioner to be produced before the authority for consideration.
your ladyship is already quoted there.
Only एक clause नहीं है, आप पूरा text.
ठीक.
ऐसे नहीं होता.
Item 4, WPS 62227 of the 2023.
Transfer.
Yes, ma'am. This is a transfer.
You
And
want to stay in Jamshedpur at one college?
I have been, any college I have submitted, because in the last 5 years
You
I
are
have,
insisting on one college.
no, not in one college,
Let
that,
us see the dates of it.
sorry, madam?
Let us see the dates of it.
Yes. The first is Annexure 3 at page 40,
And it should.
at page 40. Date is 13/7/2019.
From
From Workers College, Jamshedpur to Ghatshila College, Ghatshila.
Ghatshila College.
Yes.
How far is this?
Ghatshila from Jamshedpur would be around 50-60 kilometers. I think so. I'm not very clear. Maybe.
Anyways, this is the first transfer.
First transfer.
Second,
Second is page 41,
page.
dated 18/2/20.
Right.
This is from Ghatshila to Majgaon. This would be of some distance, around 80-90
To
kilometers.
Majgaon.
Majgaon. The college name is Majgaon, Degree College, Majgaon.
Okay. Then,
Then the third is at page 42. This is dated 26/10/21
26/10/21.
from Majgaon to Singhbum College, Chandil.
With regard to these, there was no representation.
No representation.
Then,
Then annexure 10, page
so
47.
with regard to this, you made a representation. Annexure 6.
Yes. No, this is for extension of lien. In cases of principals,
Oh, all right.
principals,
This is for extension of lien.
lien means they are for a period of 10 years only. They are essentially in the cadre of teachers. They become principals. First period is 5 years, then
That's
extension.
right.
Yes.
Okay, next.
Then is
Order of transfer.
page 47. I was given additional charge.
This is not a transfer order.
No, this is an additional charge. This is not a.
Let's forget.
Yes, we'll forget that.
Next.
Then page 52.
Page number
52. This is 24/1/23. Wait a minute. Probably this is 53.
This is
52.
52. This is 4/3/23.
4/3/23.
23. This is from
This is from
Chandil to Sarai.
Seraikela.
You just see against this you have represented annexure 17.
17 representation is made to transfer
Let me
him
read it, please.
to graduates.
Humble prayer and request.
A humble prayer and request for my transfer as principal in graduate school, College for Women, Jamshedpur, where position is likely to be vacant. I am representing that you please post me there. Vacant on July as continuation in KS College, Saraikela is not possible due to frequent travelling after open heart surgery, advised by doctor. So this was
Then
a,
what happened? Pursuant to this, so you made a representation.
yes.
Pursuant to this,
This is a representation. Then I have been given additional charge of this college at page 55. Please to transfer Dr. B.N. Prasad, Principal, KS College, Saraikela to Graduate School. So this is the transfer order where by which I have been transferred
Page 55.
55 months. In exercise of powers vested in him under section so and so, as adopted and amended up to date, the Vice Chancellor has been pleased to transfer B.N. Prasad, the petitioner, Kashi, so and so to the Graduate School College for Women with immediate
So,
effect.
you were transferred to Jamshedpur.
Jamshedpur for the.
Then
Then here I am transferred on 31/7/23, and then comes the order, impugned order, that is page 58. In the light of so-and-so letter, the Vice Chancellor has been pleased to appoint Dr. B.N. Prasad, Principal Council, with immediate effect. He is further directed to hand over the charge of Principal of the so-and-so for Women, Jamshedpur, to Dr. Veena Singh Priyadarshi. So after about 21 days, I am being transferred.
you see this particular order dated 31/7/2023.
Yes, ma'am.
This was absolutely in your favor,
It is in my favor.
right? But
Yes,
still
yes.
you represented against this.
No, I said, ki, please, no, representation is not for that.
Let us see what is your representation
Yes.
about.
This is to inform you that I am a commissioned regular principal of
No, you
Goa.
just read the
Concluded.
prayer only. I request you.
Therefore, based on the above, I request your blessings for my continuation as principal in Jamshedpur-based Graduate School College for Women. Frequent travel for performing duties outside Jamshedpur is not possible for me now as advised by doctors after my bypass surgery. Despite my ill health, I still wish to serve the college in a better way. If transferred, I may be allotted ABM College Jamshedpur, where position is still vacant. I shall remain very much obliged to you for this act of
You are
kindness.
insisting on ABM college.
No, I am not insisting on any college. I am
This
on.
is what you have said in 1/8/23.
No, what I have said
In
is.
spite of your posting in Jamshedpur.
No, I have said ki I may be allowed to continue here, but if you do not allow me, you post me at IBM college, nothing else. No, I'll place it once again for your lordship's consideration. May I read the second middle paragraph? Further, my request application for tenure extension beyond 5 years in December 22 was also conditional. For posting in
Was
Jamshedpur.
your transfer a sequel to your representation dated
No,
24/7/23?
no. It was not a. My request was ki please post me in Jamshedpur. That is all, because why? I'll kindly see the last document which I have annexed. The last document.
Is respondent.
Yes,
Why
I'm
is there so many frequent transfers?
My lord, his basic posting.
You consider his representation
Yes.
because you see he has medical grounds, a teacher, comfortable in Jamshedpur for many reasons, and he's almost at the fag end of his
He'll retire
service.
on 30th January 25.
So it is just a matter of 1 year.
It can be disposed of with that
Can be
direction.
disposed of.
Yes, ma'am.
Before whom will he file his representation?
Naturally, to the Vice Chancellor, through the registrar. He will give it to the registrar.
Vice Chancellor would be respondent number.
Respondent.
Ultimately, decision has to be taken by the Vice Chancellor. He has the powers under
Yes.
the Act for transfer.
He is respondent number
3.
3.
The learned counsel for the parties are present. This petition has been filed for the following relief. The learned counsel for the petitioner has referred to the various transfer orders annexed in the petition to submit that the petitioner has been repeatedly transferred from one college to another in different locations, sometimes within Jamshedpur and sometimes outside Jamshedpur. The learned counsel has also submitted that on account of medical reasons and the petitioner has been representing before the authorities to place him in one or the other college in Jamshedpur,
Which are lying vacant. The
which
post.
are lying vacant.
The-
The learned counsel has submitted that on account of frequent transfers, the petitioner has suffered lot of inconvenience. There is no stability in the matter of his residence. There is no continuity in the matter of his residence, which may also harm his teaching in the concerned college, right?
He's not teaching administrative position in the
Administrative position in the
college.
concerned college. The Learned Council has submitted that in view of the aforesaid circumstances, the respondents be directed to look into the grievance of the petitioner and consider the same sympathetically, particularly in the light of his medical condition, and if any vacancy is available in Jamshedpur, and if there is no other legal impediment, he can be stationed at Jamshedpur. The petitioner is scheduled to retire in the month of
31st January 2025. January 25.
in the month of January 2020. The Learned Council for the respondents has submitted that no counter affidavit has been filed in the present case.
Yes.
The petitioner does not have any right to be placed in one or the other country. But the grievance of the petitioner with regard to his posting at Jamshedpur, considering his medical condition, can certainly be addressed by the respondent number 3, Vice Chancellor, before whom the petitioner may represent along with supporting documents.
Yes.
He submits that since the petitioner is about to retire shortly, the same aspect of the matter can also be discussed.
Yes.
After hearing the Learned Counsel for the parties and considering the nature of relief sought for by the petitioner, apparently the petitioner has been placed in different locations by way of frequent transfers, and it appears that such frequent transfers has caused inconvenience to the petitioner, particularly on account of his medical condition, or which appears from the materials placed on the top. This petition, in the light of the submissions made by the Council for the parties, this petition is disposed of, enabling the petitioner to file a representation before respondent number 3 with a copy of the record, who shall consider the grievance of the petitioner and the vacancy position at various places,
In Jamshedpur.
particularly in Jamshedpur, so that the petitioner can be, and so that the grievance of the petitioner can be taken care of. This petition is according to this.
I'll file representation within 15 days, Manoj.
Representation within 1 week,
15 days?
within 15 days from today.
Along with
the
web copy.
The necessary orders be passed within a period of 15 days thereafter and be communicated to the petitioner through email, or
Could it be 4 weeks? That's all.
4 weeks and be communicated to the petitioner through email at the email ID to be provided by the petitioner in the representation.
Yes.
Item 5, WPS 7655 out of 123.
This grievance is that he was a para teacher applied under non-para teacher.
No.
Was called for counseling, but counseling was not done because that was not because of the earlier situation. Subsequently, an order has been passed in 136 or 176 LP. LP 186 of 2017, that para teacher can also apply under non-para teacher. And if he has not been called for counseling thereafter, then it is
leadership, the reason that he was provided for not appearing was different. Because of technical reasons, he could not come for the counselling at that
Where
point.
has he said?
In the previous writ, it has, in the order, it has been reflected, your leadership. And even in paragraph,
This earlier writ petition?
yes, your leadership. Even in
Yes, you are coming for the same relief.
My lord, earlier writ petition was my lord filed for fresh counselling, my lord, on the there was different issue, my lord. There was no communication and having no knowledge about the date fixed by the respondent, my lord. So that
But you were called for counseling.
call for that is admitted fact, my lord.
Then you
Call
are
for.
not entitled to this relief. You were
But,
called for counseling and you did not have it. So your statement
My
in this
statement is
writ
there.
petition
Yes, my lord.
that you were not permitted to participate is not correct. It is
I have not
contrary-
participated, but
No, you have stated that you were not permitted to participate.
I have filed second representation, my
No.
lord.
Yeah, para number 10.
That
The
is
concerned authority did not permit you to appear. This is not correct. Para number 10 is not correct.
Yes, but concerned authority not permitted
So
to
this is not
appear in the
correct.
same counseling for para teacher category.
This is
And
not the
thereafter,
correct statement. Where was his statement that he could not, where is it mentioned in the last order? Came to know belatedly due to non-communication. The learned counsel for the parties are present. This writ petition has been filed for the following relief.
then my lord may be allowed to withdraw this.
The learned counsel for the petition, after some argument, the learned counsel for the petitioner seeks permission to withdraw this writ petition. Any objection? Vote the pair. Only one submission of yours I have. The learned counsel for the respondent has referred to order dated 30/4/2018 passed in WPS number 3215 of 2016 and she submits that no case for fresh direction for counseling has been made out. After some argument, the counsel for the petitioner seeks permission to withdraw this petition. The counsel for the opposite party has no objection to the prayer for withdrawal. Accordingly, this petition is dismissed as withdrawn.
साइन कर दिया सर.
So on page list for orders item 5, Criminal Division 607 of 2022.
The criminal revision number 6777 of 2022. This matter has been listed at the instance of the office. It has been reported that in order dated 15 February 2024, passed in criminal revision number 207 of 2022 and other analogous cases. The revision case has been wrongly mentioned as criminal revision number 667 of 2022 instead of criminal revision number 677 of 2022. Considering the aforesaid fact, the order dated 15 February 2024 passed in criminal revision number 207 of 2022 and other analogous cases is hereby modified and the first item, criminal revision number 667 of 2022 is directed to be read as criminal revision number 677 of 2022 on account of typographical error. Based is that is
6 WPS 330 of 2023.
Who is for the respondents? Who is, where is he?
Mr. People,
When you call him?
Item 7 WPS 1084 of 2023.
You mean day after tomorrow? He said day after tomorrow. Day after tomorrow would be on Monday. Otherwise ready? Counter affidavit has been filed. Everything is ready? WPS number 1084 of 2023. Counsel for the parties are present. At the request of the counsel for the petitioner, hold this case on Monday.
Item 8 WPS 2262 of 2023.
WPS number 2262 of 2023. IA number 8298 of 23 has been filed seeking intervention in this case. Intervention has been allowed. You are for the intervener? The learned counsel for the petitioner. Intervener submits that the matter relates to HSC seniority.
Promotion is petitioner's
The matter relates to promotion, and therefore, if any order is passed in the present case, the intervener will be affected. Considering the aforesaid submissions, the IA number 8298
Your Lordship, we have
of
not received the
2023 is
copy.
hereby allowed. It is just an intervention.
Your Lordship will have to file a reply to the intervention, Your
You
Lordship.
don't need to.
Your Lordship, we have to see the copy of the IO at least.
You just have a look at it. You look at it.
I have an instruction to file a reply, Your Lordship. 2 weeks time will be given, Your Lordship, to file a
What is
reply.
this? They are seeking intervention because it's a matter of promotion. If they are affected,
I'll just
so
have a look and
unnecessary, don't linger the matter like this. You can just have a look at it. I can pass it over.
yes, Your Lordship.
You just have a look.
And
Item 9 WPS 2583 of 2023.
Yes, petitioner.
This is for appointment of the son of the petitioner against the medical unfitness of the father who was working under the respondent authorities methods. The claim has been rejected, stating that the scheme for employment is under vogue since 2018, my lords. It's been 6 years, and still they are saying that the scheme for employment under medical unfitness is under vogue.
They have attained the age of superannuation.
No, my lords, the petitioner is 54 years old.
From which is the document on the basis of which you say that this particular scheme for medical appointment against medical unfitness is not
9.4
in
your
vogue?
lordship. 9.4 your lordship that in the read petition also you
Where is
annexed
that
your lordship.
circular? Where is
It's all-
that circular? Where is that circular? Where is that circular?
Yes.
Have
NCW
you
your
annexed a
lordship.
copy of the circular that it has been suspended?
No, my lords. They have submitted in only a verbal submission is there in the counter affidavit.
Where
At
is it? Where
para
is that
number
decision?
That page 32 your lordship.
32 of?
Read result order your lordship which has come.
Reasoned order, no, I want that circular. What is this reasoned order? If any provision of NCWA is not under implementation petition as of now, there has to be a decision to that effect, isn't it? NCWA has the force of law.
Yes, Your Lordship.
So orally you will say it is not invoked.
At page
For
30.
the, Your Lordship, may kindly see the page 34 of the read petition, Your Lordship, that the NCWA has annexed 9.3, 9.4 and 9.5.
Yes.
So far the monetary, Your Lordship, it has also come.
No, you just tell us 9.4.0. What is the status of 9.4.0?
Lords, in page
It is not
34,
decided,
it
Your
has been
Lordship. It is
stated,
also is
if I may, Lords. In
The
page
status for
34,
the last year.
first point, my Lords, the clause 9.3.0, 3.4.0 and 5.0 of NCWA 6 will be operative in NCWA 9 till a revised scheme is jointly.
Yes.
My Lords, I have a copy of NCWA 6, my Lords. In this, there is a provision in detail, my Lords.
Yes. In the counter affidavit also you have not annexed any such decision. You go through the record and come in the second.
Your Lordship, only 2 weeks. 1
No,
week.
no, you have filed your counter affidavit.
नहीं ये काउंटर मेरा फाइल नहीं किया हुआ आल्सो एडवोकेट योर लॉर्डशिप खालिदा जिया का फाइल किया हुआ
Client ने sign किया है ना?
हाँ
फिर you will
तो-
resolve this counter affidavit.
नहीं
Then-
आई एम नॉट डिसऑर्डर
No, we will not permit this because medical disability and medical unfitness, we are seeing so many cases of medical unfitness. They are to be examined. In most of the cases, you say now he has attained the age of superannuation, so nothing is done. So we do not pass any order on that. But he is still in service.
still in service and in
100%
leave your lordship
100% blind. You want to keep him?
second half I have taken instruction your lordship
इनको भी दे दीजिए या अभी दिए second half.
Item 10, WPS 2746 of 2023.
Petitioner, do you want to file a rejoinder? Counsel for the parties are present. Counsel for the petitioner prays for and is granted time till 7th of March 24.
One more week.
Okay. 14th of March?
Yes.
You want more time? I'll give you 6 months.
No, 14 March.
14th of March 24 to file a rejoinder to the counter affidavit, close this case under the heading for final disposal on 27th of March 2024. The parties to file short synopsis, list of dates and the judgments which is seek to rely upon, latest by 20th March.
Item 11, WPS 2868 of 2023.
The law counsel for the petitioner, MS Nurseena, seeks permission to withdraw this petition and submits that the grievance of the petitioner has been redressed. Counsel for the respondents has no objection to the prayer for withdrawal, but so far the redressal of the grievance of the petitioner is concerned, we are no instructions. Considering the opposite submissions of the petitioner, this petition is dismissed as withdrawn.
साइन कर दीजिए
Item 12, WPS 2730 of 2023.
Last year, by the petitioner, we have filed it also, and a query was raised by that whether the appeal has been referred by the petitioner or
No,
not.
that was not the case.
That has been referred.
The query was that there is no disclosure in the
Lordship, but from the appellate orders, it is apparent that the appeal was referred within 3 months. Lordship.
So what the point is that when you file a writ petition, simultaneously you prepare an appeal. And you
Before-
do not disclose this material fact before this court.
Lordship, before filing this writ petition, we have referred the appeal before the
Where
competent.
is your disclosure in the writ petition? Show me one paragraph. We will not permit anybody to have parallel remedies.
Yes. And the appeal was disposed of on 17th of November, Your Lordship. That is after the.
Appeal was filed prior to filing the
Yes,
correct?
that is.
You have not disclosed it. We will not permit you to pursue this. You filed
Lordship,
a
one
fresh-
chance may kindly be given.
No chance is required to be given. I have passed a specific order for you to explain. And you have filed and joined just 2 days after that without explaining.
That was ordered by Your Lordship that the rejoinder should be filed by Monday, Your Lordship.
So you see, you have not disclosed and you have filed that. I just, suppression is a very serious thing for me. I just can't take it. You see, you filed your appeal, come to page number 16 of the journal. You don't need to do anything more. जो राज्यपाल सचिवालय के कार्यालय पत्रांक 3168 dated 17/11/22 एवं मंत्रिमंडल सचिवालय निगरानी विभाग के पत्रांक 1366 dated 8/6/23 के माध्यम से विभाग को प्राप्त हुआ। तो 22 को प्राप्त हो गया। अब रीड पिटीशन का फाइल 23 में
yes,
you have not disclosed it. No relief can be granted to you. You file a fresh petition. That I will just take.
Lordship, I am seeking a short passover. I would like to.
So who will argue then?
And I will argue, Lordship, just to seek instruction, Lordship, regarding this.
सवा 12 बजे तक आपको शॉर्ट मतलब शॉर्ट.
Item 13, WPS 3644 of 2023.
Earlier you occasion this case by a third by Lordship, the Lordship is question regarding my level. So Lordship is permitted to withdraw its liberty to move the appropriate form.
WPS number 3644 of 2023. The learned counsel for the petition seeks permission to withdraw this petition to avail his remedy under Jharkhand Education
It is a lawsuit. Education tribunal.
Before the Jharkhand Education Tribunal, which he submits is the appropriate remedy for the purposes of redressal of his grievances. Considering the submission, this petition is dismissed as withdrawn. Liberty is reserved with the petitioner to pursue his remedies.
Lordship.
Sign कर
Item 14, WPS 4191 of 2023.
In this case, Lordship, petitioner claim has been rejected in compulsory appointment, Lordship. The issue involved in this case already decided by the LTA court, Lordship, and the circular already implemented by the bank, Lordship. So may dispose of it in light of the LTA, Lordship.
Then you withdraw it. They have already implemented it. I will just observe that you want to pursue them in view of this judgment.
May dispose, Lordship.
Then you have to satisfy that.
Your Lordship,
Is it covered by this judgment?
no, considering Your Lordship may keep it in first week of April. By that time, decision shall come from the head office, and it is under consideration.
With regard to the petitioner?
Regarding him, it is under consideration. So,
The
in
learned
April
counsel-
first week.
The learned counsel for the parties are present. The learned counsel for the petition submits that the case of the petitioner is squarely covered by judgment passed by this court in LPA number 325 of 2020, wherein the circular of the board, circular of the respondent bank has been considered and interpreted. Counsel for the respondents on instruction has submitted that the claim of the petitioner is under active consideration of their head office and decision is likely to be taken shortly.
April.
No, I will not adjourn it, I will dispose it of. You will consider this LP also. Considering the submissions made by the learned counsel for the respondents that the matter regarding compassionate appointment of the petitioner is under active consideration of the head office, this court is of the considered view that no useful purpose will be served by keeping the present case pending. it is sufficient to observe that the authorities will take into consideration the judgment passed by this court in LP number 325 of 2020 dated 3rd of July 2023 by considering the case of
10 weeks time may be given.
the needful be done by the respondents within a period of by
End of
10th
April.
of April.
By the end of April, Your Lordship.
Okay, by 27th of April. 27th of April 2024. Who will take the decision?
You take the decision.
Milord, the head office. Here, Milord, chairman. Here is the chairman.
Okay. And the decision.
Chairman come managing.
And the decision be communicated to the petitioner by the respondent number one. Two speakers. The decision in connection with the petitioner should be a reasonable. This petition is here. This one has not gone into the merits or otherwise. Yes, counsel, please come. In this case, no counter affidavit has been called for. Accordingly, this court has not gone into the claim of the into the merits or otherwise with regard to the claim of the petition. It is for the respondents to take decision in accordance with law, taking into consideration the applicable rules, regulations, and judgments.
Item 15, WPS 4593 of 2023.
This is a matter in which compassionate appointment for the widowed daughter-in-law, that is the petition number 1, has been rejected by the BCCA on the ground that the direct dependent is available, which is petition number 2. But as per the clause 9.3.3 of NCWA, if your ladyship may come to page number 18.
Petitioner number 2 wants petitioner number 1 to be granted.
Yes, your ladyship.
Milord, since the wife of the deceased employee is still alive and she being the direct dependent, the management says that she should take monetary compensation. Today as on date, the monetary compensation is around rupees 30,000 per month.
No, you cannot choose. You cannot dictate. You have a policy, you go as per.
Our policy says that if a direct dependent is available, then she would get the first benefit. She has the first right. If there is no direct dependent available for employment, then indirect.
She is otherwise eligible for employment, and where is your policy regarding that?
I need to file a counter.
The DPS number 4593 of 2023. Counsel for the parties are present. Counsel for the petitioner submits that the petitioner number 1 is the daughter-in-law,
widowed daughter-in-law,
of petitioner number 2. The husband of petitioner number 2 was in service, who died in service. The learned counsel submits that. Petitioner number 2 has.
Husband of the petitioner number 1 was in.
No, 2. The learned counsel for the petitioner has submitted that petitioner number 2 is supporting the case of the petitioner in the matter of grant of compassionate appointment as per NCWA, but the respondents have rejected the claim by saying that once the petitioner number 2 is eligible, the relief cannot be granted. Once the petitioner number 2 is eligible for monetary compensation, the relief of compassionate appointment cannot be given to the petitioner number 1. The learned counsel submits that the review order calls for interference. The learned counsel for the respondents submits that there is a policy decision to this effect to support the impugned order, but he needs to file a counter.
Yes.
You file it in 1 week. The counsel for the respondents is directed to seek instructions and file a counter affidavit in the present case by 4th of March 2024, annexing the policy of the respondents that if a person is if one of the dependent is entitled for monetary compensation, then compassionate appointment
Cannot.
will not be given to the
The
other
indirect.
dependent.
The indirect dependent.
The indirect.
The widow would be the direct dependent. She being the widowed daughter-in-law would be an indirect dependent.
Widowed, are you aware of Hindu Adoption and Maintenance Act?
Our scheme says, my lord, that if the widow is available, she would have the first right. If the widow is not,
She will have the first right to claim compassionate appointment, isn't it?
If your ladyship may.
We'll see. Post this case on the 6th of March 2024. Should I post it for final disposal?
ma'am, it may be disposed of. If
No, it will not be disposed of.
no. What I am saying is, madam, if I file my counter affidavit, it will be disposed of. So
Let it be on final disposal. If you need a rejoinder, we'll see. But prima facie, they don't have this. Yes. For final disposal on 6th of March.
Passport case item 6, WPS 330 of 2023.
Matter has finally, your lordship, now there was your lordship Ram Kumar Gijroya case earlier. That the caste certificate can be submitted at any time, which was interpreted by this honorable
No,
court.
we are not right. He submitted a caste certificate. Your ground is that he submitted a caste certificate with a heading that it is for government of India. That is your.
That is my case.
You just compare the caste certificate issued by government, that heading government of India and your state.
My lord,
It is copy paste.
No, my lord. Only your lordship. That is the
You
judgment.
just tell us.
My lord, kindly see your.
How can you be so parochial and bureaucratic?
My lord, kindly see your lordship. My lord, what is the difference between your lordship, the central government format and the state government format? My lord, if there would not have been any difference between the central government format and the state government format, your lordship, then there was no necessity to prescribe.
You just explain.
My lord, I am
A
explaining.
person who is a scheduled caste or a scheduled tribe belonging to the state of Jharkhand
Your lordship.
gets a caste status certificate, right?
My lord, kindly.
Therefore, that particular caste
My lord,
certificate
my-
will be applicable for the central government jobs also and for the state
No,
government jobs also.
my lord, difference.
No,
My lord,
suppose it-
difference, your lordship. With due respect, your lordship, there is difference, your lordship. My lord, in this case, your lordship, the petitioner has
Otherwise, the petitioner is well qualified.
well qualified, my lord. That is not the issue, your lordship. Now, in Dibya case, your lordship,
No, you just cite this is the issue and we will decide it. You cite whatever judgments will come tomorrow or maybe on next week. You get all the judgments. Prepare your written submissions. This court is not with you. I'm telling you very frankly.
my lord, that is immaterial, your lordship.
No,
I have to,
therefore-
my lord, I have to
therefore-
only assist your lordship.
Yes,
My lord,
so
I have
therefore,
to.
whatever judgments you want this court to consider, you please produce.
My lord, I will bring your lordship. My lord, there are several judgments of this honorable court, your lordship. That is of
You should
division
have
bench.
brought at least one.
My lord, I have brought your lordship. I have brought your lordship. Your lordship, one, your lordship.
You give us the list of judgments. You just give
My
us
lord,
the list.
yesterday I have given all judgments, your lordship, in the caste certificate, my lord. My lord, before in another case.
Okay, give the same set.
Same set, your lordship, I will be giving, or let it be after 2 weeks, your lordship.
2 weeks.
My
I
lord.
disclose my mind. I will not adjourn it for 2 weeks.
My lord, that will consume time, your
No,
lordship,
no,
considerable time, your lordship.
we are not in a hurry. Are you in a hurry?
No, my lord, I
We are
am.
not in a hurry. We will hear the case patiently. Let other cases wait. But we are not in a hurry. I'm never in a hurry. I've disclosed my mind.
My lord, that is your.
As it is, you know what all are the judgments to decide.
My lord, I am well aware, your lordship. I am well, your lordship. I have to only assist your lordship whether the caste certificate as submitted by the petitioner is valid for extending the benefit of reservation in the terms of the advertisement. My lord, because your lordship, this honorable court and honorable Supreme Court has been pleased to hold, your lordship, that the High Court under exercising power under Article 2
No,
to
we
6.
will hear you. We
My
will,
lord,
we will
let
hear
it
you
be
on
after
every-
10 days, your lordship. Let it be. I will.
I will post it on Monday.
Monday. I am out.
No, I have disclosed my mind. You
My
see,
lord,
please
only one.
appreciate. It can't be like
My lord,
this.
only one problem.
I have disclosed my mind prima facie. subject to
My lord, prima, that is always your lordship, your lordship. My lord, only
Then it
problem.
comes for the parties.
Only
The
person.
pleadings complete. The pleadings as he takes his complete, the
Why not he has not submitted the reply as yet?
need not. He doesn't want to. Do you want to?
No.
The learned counsel for the during the course of hearing, it transpired that the petitioner had initially produced a caste certificate titled Certificate to be Issued to Persons Belonging to a Scheduled Tribe Applying for Appointment to Post / Admission to Central Educational Institute within bracket CEIS bracket under the Government of India, which was issued on 4/3/2020 by the competent authority.
And in the bottom, my lord,
Yes.
it is written
We'll
that
see. And thereafter, at the time of his counselling, he produced another caste certificate also, which is dated 4/3/2020, titled Certificate to be Issued to Persons Belonging to a Scheduled Tribe Applying. Sorry, the certificate to be. This is dated 9/11/2019. 9/11/2019 within brackets, caste certificate to be issued to persons belonging to a scheduled tribe applying for appointment to post / admission under the government, which was issued on 9/11/2019. The learned counsel for the petition has submitted that there is no difference so far as the content of the caste certificate is concerned. It is not in dispute that the petitioner belongs to a scheduled caste, scheduled tribe category in the state of Jharkhand. The learned counsel for the respondents has submitted that the caste certificate produced by the petitioner initially was not in consonance.
Initially, no, but the produced why not? Whatever the
The
documents
caste
of
certificate which was uploaded by the petitioner in the web portal was not in
Along with
accordance
his
the
application form.
advertisement issued, and therefore the candidature of the petitioner has been rightly rejected. The learned counsel submits that there is no other impediment except with regard to caste certificate. The learned counsel submits that in order to adjudicate this matter, he wants to, in order to assist in that matter, in adjudication of this case, he wants to produce certain judgments, and he submits that the matter will be posted on 11th March. 11th March under the heading for final disposal. Let the parties are directed to file a short synopsis of its case, list of dates, and the judgments which they seek to rely upon, pointing out the relevant paragraphs of the judgment, latest by 14th of March. Let this matter be taken up.
I will assist your lordship because your lordship now your lordship is several orders on the same issue. But not there cannot, and in this advertisement your lordship the same has been already decided by the coordinate bench. But I will produce you.
I have recorded that the contents are identical.
You have recorded your.
The contents are absolutely identical.
My lord, that is your lordship's observation. I will show your lordship that the same is not valid.
Also, case item 8, the LPS 2262 of 2023.
Objection?
After the counter will file a detailed rejoinder.
Certainly. WPC number 2262 of 2023, counsel for the parties are present. The counsel for the intervener has submitted that IA number.
IA number 8298.
Sorry.
8298.
8298 of 23 has been filed seeking intervention in view of the nature of relief sought for in this petition. We submit that if any order is passed in this case, the same will have direct bearing on the matter, the direct bearing upon the intervener. The counsel for the petitioner has no serious objection to the player seeking intervention, and considering the nature of relief sought for in this petition, IA number 8298 of 23 is directed to be added as respondent number 7. No, respondent number 7 in this case. The counsel for the intervener is directed to carry out the necessary amendments in the necessary amendment in the cost item in ready during the course of the hearing.
It would be 7 to 13 because we have 7 numbers.
7 members.
Yes. 7 to 13.
7 to 13.
Yes. Paragraph 29 I have given.
The counter affidavit has been filed. The newly added, the state is directed to serve a copy of the counter affidavit to the newly added respondents. The newly added respondents are pray for 4 weeks time to file a counter affidavit in the main writ petition. Rejoinder 2 weeks thereafter. Pose this case on 6th of May 20. Under the heading for admission. Admission.
Let's do this.
Also case item 12, WPS 2730 of the 2023.
Yes, petition.
I would like to withdraw this case.
WPS number 2730 of 2023. Learned counsel for the parties are present. Learned counsel for the petitioner has granted seeks permission to withdraw this petition. He submits that some error has crept in and therefore some error has crept in and during the pendency of this case, the appeal has also been dismissed. Considering the repeated submission, this petition is dismissed as withdrawn. Liberty is reserved with the petitioner to take appropriate steps in connection with the rare rule in the present petition, as well as with regard to the order passed by the applicant.
साइन कर दीजिए.
Item 16, WPS 4653 of 2023.
In this case, we have come before this honorable court with a humble prayer for directing the JPSC, your lordship, to give direction for promotion of the petitioner to the post of university professor. Please just have a look to annexure 4, that is at page 33.
Have they rejected your plea?
No,
Have you
they have neither rejected nor,
Have you represented?
yes, the representations all start from annexure 1, page 17.
You moved earlier also.
That was for transfer. Against that, they went to the Honorable Division Bench, that was also dismissed. And subsequent to that, although I was entitled for being promoted to the post of university professor, my case was recommended as far back as 7/4/2006, that is annexure 4, page 33.
What happened in the inquiry? There was some disciplinary proceeding.
No, nothing. And now I have already retired from my services.
When did you attain the age of
2017, that I have stated as paragraph 6.
Page number 26, in the certain order was passed, not only debarring you from, not only you were transferred, but you were also debarred from claiming any seniority. Right? Then it was set aside on account of violation of principles of natural justice.
They went before the division bench challenging that order. That was also dismissed.
The university has a remedy to proceed against the respondent. So did the
No, nothing.
Who is for the respondents?
I'm for the university, but he is asking really, but for the document kindly say what is his prayer? Prayer is that call for all the records.
No, that we are not going to do.
That is
It
the
your record,
whole
you keep the
file
record.
from the both universities. It should come to this court. And now
You don't go, you go to the crux of it.
Yes,
It's agreed by the fact that he has not been granted the
promotion after retirement he is coming from this to this school.
He is not entitled.
No, I don't say not even if it was entitled, but what was the date of his entitlement?
So that you consider. Who will consider that?
No, he has asked for JPSC to consider. I kindly send it for.
No, first the matter has to be sent by the university to the JPSC.
They have already sent it.
You have already sent it?
Yes, that is what, that is annexure 4.
This was way back in 2006.
6.
The council for the parties at present, the learned council for the petitioner has submitted that the claim for promotion to the petitioner was sent to Jharkhand State Public Service Commission, who is called JPSC, way back as on 7/4/2006. But the case of promotion of the petitioner was not considered. The learned council has, during the course of argument, it appears that one order being that the petitioner was earlier transferred and the same was challenged by the petitioner in WPS number 4085 of 2007, and the order of transfer was set aside by the order dated 5/2/2008 by observing that by the improved order the petitioner was not only transferred but he was also debarred from claiming his seniority, and such order was prejudicial to the interest of the petitioner. Against the said order, the respondent university filed appeal being LPA number 66 of 2008, which was disposed of by order dated, which was dismissed by order dated 25/11/2008, observing that whereby this court refused to interfere with the order setting aside the transfer, but it was also observed that this university, that the university had still a remedy to proceed against the respondent number 1, that is the present petitioner. Upon inquiry of this court, the learned counsel for the petitioner has submitted that after the order dated 25/11/2008, no adverse order was passed by the university, and his recommendations for promotion sent on 7/4/2006 remained pending. Considering the from the perusal of the records of this case, no adverse order has been placed on record so far as the petitioner is concerned, which might have been passed after order dated 25/11/2008.
But Annexure 4 says beyond that his claim has been recommended to JPSC. Only that matters now.
Just the learned counsel for the respondent university has submitted that the petitioner has prayed for calling for entire records of the university, and the crux of the grievance of the petitioner is with regard to his claim for promotion. She submits that appropriate order can be passed so that the claim of the petitioner can be considered in accordance with law. And as per Annexure 4, the matter has already been referred for consideration to the JPSC by as back as on 7/2006. She has submitted that no counter affidavit as such has been filed in the present case. If the case of promotion of the petitioner has already been considered, then there may not be any requirement for fresh consideration. Right? After hearing the learned counsel for the parties, this court finds that on the face of the petition, a recommendation was made for consideration or promotion of the petitioner by the respondent university to JPSC as back as on 7/4/2006, and subsequently certain orders were passed against the petitioner, which was not only a transfer order but also a punitive order, which was subject matter of challenge in WPS number 4085 of 2007, dated 5, and was allowed wide order dated 5/2/2008. The findings of the writ court is as under. Thereafter, the respondent university filed appeal, being LP number 66 of 2008, which was dismissed by the order dated 25/11/2008, observing that the university still has a remedy to proceed against the respondent number 1. The operative portion of the order passed in LP number 66 of 2008, dated 25/11/2008, is quoted as under. It has been claimed by the petitioner that no adverse order has been passed against the petitioner after 25/11/2008. Apparently, this court finds that the recommendation for consideration or promotion of the petitioner was issued by the university prior to the orders passed by the High Court in the writ petition and LPA. Therefore, under such circumstances, this court is of the considered view that the aforesaid facts of the petitioner as submitted by the petitioner is required to be verified at the end of the university. And since there is already a at the end of the university at the first instance, the university is directed to look into the records and if there is no adverse order in the records of the university after the order against the petitioner after order dated 25/11/2008, the university is required to take up the matter with JPSC so that the claim of the petitioner for promotion is taken to a logical end.
One more thing I am requesting, because by this reflex of time, there the college under comes under BBMK University. The police also party over here. Because all facts, figures and files have been transferred to that university. So
at this stage, the learned counsel for the respondent Vinoba Bhave University has submitted that the case would now fall under Vinod Bihari Mehto University, Dhanbad.
In consultation, my submission is because in consultation of both the universities, if the action can be taken, because now it is not with me, or they will say it was at that point of time it was with you. I think there must be some
the learned counsel has submitted that there may be a requirement of consultation with the other university, namely Vinod Bihari Mehto University, Dhanbad. Will you record your appearance? At this, the council, the retained counsel of Vinod Bihari Mehto University, Dhanbad has appeared before this court and submits that needful will be done and the records of the petitioner will be verified in consultation with Vinoba Bhave. Accordingly, this petition is disposed of, enabling the petitioner to first approach the respondent to the registrar Vinoba Bhave University, as well as to Vinod Bihari Mehto University, who, in consultation with each other, shall verify the records of the petitioner and take up the matter with the registrar with the secretary, Jharkhand as Jharkhand Public Service Commission, so that the claim of the petitioner with regard to promotion is taken to a logical end, in as much as the recommendation for in as much as in view of the earlier letter dated 7/4/2006, it is observed that if the claim of the petitioner for promotion has already been considered, no fresh consideration is required. A copy of such consideration will be just forwarded to the petitioner by the respondents.
Only one thing, page 17 may also be recorded. And if it is not considered, then also a time limit may be given that it should be considered. Page 17, the fourth paragraph.
If the claim for promotion of the petition has not been considered so far, then it will be done within a period of 6 months from the date the communication is received by the university to JPSC. The university is also directed to do the needful within a period of 6 weeks from the date of communication.
And other 3 persons whose names were recommended, they have now been promoted. That also I have stated at page number.
You raise all your grievances in the representation. The petitioner to file his representation along with a copy of the reports and giving the foundational details in support of his claim.
Sorry, my lord, serial number 14, my lord. Earlier in this case, my lord, earlier, my lord, court directed to file counter affidavit and no counter affidavit filed, my lord. Today, my lord, your lordship disposed the matter, my lord.
We have disposed it, we do not know. Next complaint.
Item 17, WPS 4710 of
My lord,
2023.
soonly, my lord, I am ready to argue, my lord.
What have I done?
Serial number 14.
I do not know. You do not come when the case is taken up.
I saw. Sorry,
The
my lord.
appearance of both the parties has been recorded.
I am not a peer.
I just do not know. You just.
I am for petitioner.
केस नंबर बोलिए
केस नंबर 14
केस नंबर
3227
फर्स्ट हाफ में ये केस नहीं है
सेकंड
Why do you disturb the court proceedings like this? You don't see the list?
My lord, this is case of payment of gratuity and leave encashment, and this case is squarely covered by way of Annexure 7, my lord, height order dated 10/7/19 in WPS 738 at page 69, my lord, 738/17. Same bank, same respondent, only staffs are concerned, the same prayer, my lord. So it may be disposed of squarely covered.
The learned counsel for the parties are present. The learned counsel for the respondents is directed to seek instructions. And file a counter affidavit in the present case by 3rd of April, rejoined by 10, post 160 of April under the qualification.
Item 18, WPS 4980 of 2023.
In last occasion, Honorable Court had directed to file counter. That has been filed.
There is no direction to file counter. Where is the order?
11/12/23.
There is no order sheet.
Item 18, 4980.
3980.
4980.
Who is for the petitioner? You are appearing in person?
Yeah, my lordship. I am retired forest officer, my lordship. I was appointed by the Bihar Public Service Commission, and I went into the training in 90.
What is your grievance? What is your
My grievance is that salary during the suspension period, and my lordship, another one is the during the suspension when the petitioner was under judicial custody, and the petitioner was requested several times before the respondent authority. They didn't consider. Then petitioner filed the petition before this Honorable Court, and the Honorable Court has passed the judgment in my favor and passed the suspension order. But they
File your counter and you ensure that the admissible dues are paid.
My Lordship.
We will not go to you. Why should we go? Admissible dues should be paid to him.
Lordship, at page number 138, earlier he had moved before this honorable court, and he has stated that against that order, after that order, Lordship, he has also filed a contempt application which has been dismissed and dropped. So,
But liberty has been given, my Lordship.
No, it doesn't make any difference. You just file your, either you say that he does not have any surviving claim.
yes, Lordship.
Or whatever is admissible, you pay and file your act. That is case number
But
498.
one submission, my Lordship, they have violated the rules. That's why no need of further any counter in this regard. My Lordship, just see 1 minute. I will take 1 minute.
You are an advocate by profession now?
I had completed my law, but I am
so
not
therefore you
professional.
should know that no order can be passed in your favor without giving them an opportunity. What I am saying is, whatever is admissible, they will pay or they will oppose the report.
But short duration may be given, my Lordship.
The DPS number 4980 of 2023. The petitioner, appears in person, counsel for the respondents is present. Counsel for the respondents is directed to seek instruction and file a counter affidavit in the present case by 4th of April.
It is
Just a moment. 4th of April.
my family, entire family is hand to mouth, my Lordship. I am retired. I am not getting my any salary from any corner of the. They are not paying the pension also, and the writ
By
petition is
6th of March. The counter affidavit should specifically indicate the admissible amount, if any, which is payable to the petitioner, and the readiness and willingness on the part of the respondents to pay the admissible amount to the petitioner. The affidavit should be filed by respondent number 1.
to my Lordship, Additional Chief Secretary of the Forest Department.
Planning from Finance Department.
Additional Chief Secretary, Planning of
Respondent number 1.
One loss.
Char.
By the respondent number 1.
He has made 2 persons as a party in name, by name.
That has been
5 and
deleted.
6.
That has
You forget the name. You just pay the admissible by the respondent number 1.
Lordship, in the prayer portion, he has mentioned substantial allowances. It
Exclusive
should be
is-
subsistence. It should be subsistence.
You know what does it mean? What is the use of language? That it should communicate well. The learned counsel for the respondent state has also submitted that. In the prayer portion, the word subsistence allowance has been wrongly mentioned as
Substantial.
substantial allowance. The counsel for the respondents, the respondent by filing the counter affidavit should read the word subsistence allowance instead of
I'm sorry. I have left my Lordship. Date, my Lordship.
Date I have already given. By 6th they will file post on 11th March
I have applied.
under the same heading. Let us see your counter and then we will decide.
Yes.
Item 19, WPS 5314 of 2023.
The petitioner has challenged the order of suspension annexure 4 dated 15/2/2023. The further prayer, the departmental proceeding was not yet been initiated. The response
It is just how many days back?
15/2/2023 को 1 साल के, but they have filed the response without annexing the order of initiation of departmental proceeding. In paragraph 8, they have stated
They will
that
give you a copy.
they have
Provide you a copy. Where is it?
Lords, we have not annexed, but we have stated it on
On-
that.
Provide them a copy.
Yes,
Where is
ma'am.
it? mentioned?
Para 8 of the counter affidavit, my lords. That
12
departmental proceeding has been
2023.
initiated before filing of this writ petition itself.
During suspension, my lord, from Dhanbad, I was directed to join, my lord, at Daltonganj. My lord. That was not communicated. My lord.
You provide him a copy?
Yes, my lord.
And then he shall proceed.
Yes.
Who will provide him?
One moment. Lords, the Under Secretary cum Assistant Director Land Records and Survey. 1 moment, my lord.
Under say respondent number?
Yes, my lord.
Respondent number 1.
He has not been implemented as my lord the respondent, but he has stated that on 12/9/2023, Under Secretary cum Assistant Director, Land Records and Survey Directorate Revenue Register.
I'll ask the
My
respondent
lords,
number
respond. Yes, my lord. Yes, ma'am.
Respondent number 2 can also.
Respondent number 2 has only shown the affidavit, so
So he will provide him.
yes.
That should be sufficient.
My lords, and the time limit.
I can't fix a time limit right now. We do not know what is the stage, whether you have filed your show cause,
No.
whether you are participating, not participating.
But
The
lords,
learned
9
counsel
months,
for
6 months at least, lords, some time maybe.
Learned counsel for the parties are present. This petition has been filed for the following relief. The learned counsel for the respondents has submitted that
Paragraph
as
8.
per paragraph 8 of the counter affidavit. The departmental proceeding has already been initiated against the petitioner by letter number 375/BIREV dated 12/9/2023, issued by Under Secretary cum Assistant Director Land Records and Survey Directorate, Revenue Registration and Land Reforms Department, Jharkhand, Ranchi, and the same is continuing. It has been stated in the counter affidavit that the instant application has been filed during the pendency of the departmental proceeding. The learned counsel has submitted that the petitioner has not disclosed regarding initiation of departmental proceeding in the writ petition. Address counsel for the petitioner has submitted that the copy of the
Lord, the reason being is that I was directed, lords, to join at Palamu at Daltonganj from
The
Dhanbad.
learned counsel for the petitioner has submitted that since the petitioner was directed to join at another place and therefore the on instructions, should I say on instructions?
No, Annexure 7 is there, lords, I was directed and then I joined. I have.
Should I say that you are not aware of this?
Yeah, lords.
Because they say that you are participating.
The same is continuing and the petitioner has
Yes.
come up with the instant application during the
Continuing means what?
proceeding is continuing, Lord, but I was not informed. The reason being, Lord, the read was.
Just a moment. The learned counsel for the petitioner has submitted that since the petitioner was directed to join in another place, therefore the letter might not have been communicated to the petitioner.
और कोई पेपर लगा हुआ
He
भी
submits
नहीं
that the said letter has also not been annexed along with the counter affidavit, nor any proof of
Service of notice.
communication of the same to the petitioner has been annexed. Considering the aforesaid facts which has been brought on record in the counter affidavit that the departmental proceeding has already been initiated against the petitioner as that as on 12/9/2023, this court is not inclined to grant the relief as prayed for by the petitioner in this petition. However, if the petitioner has not been served with the copy of the letter dated 12/9/2023 as mentioned in the counter affidavit, the same be immediately provided to the petitioner. If the petitioner is already participating in the departmental proceeding, then there is no question of fresh service authorization. It is put on record that the counter affidavit was filed on 12/2023, but no rejoinder to the same has been filed to date. And therefore, there is no clarity in connection with service or non-service of the letter dated 12/9/2023, which has been mentioned in the contract. The need to be done within a period of 1 week from the date of receipt of a copy of this order by the respondent. Take appropriate steps in consultation with the authority who is said to have issued the letter dated 12/9/2023. This petition is
Item 20, WPS 5531 of 2023.
But the petitioner has retired from the post of constable last year on 31/1/2023, and he is knocking the door of this honorable court for the second time. Initially, the recovery order by Annexure 2 page number 13 was quashed by a coordinate bench of this honorable court on the ground that it was violative of principle of natural justice, and then the superintendent of police Kodarma was directed to take a the fresh order is at page number at Annexure 4 page number 21. I beg to place it. May I read it? Now, this is a recommendation. This is a recommendation made by Superintendent of Police Kodarma that since the petitioner is a third grade employee, and since he has played no fraud or misrepresentation with the department, therefore the recovery proceedings should be dropped. This recommendation has been made to respondent number 2. Now, respondent number 2 is sitting over the matter tightly. 7 months have gone by, the respondent number 2 is not taking any decision. The consequence of the same is that my pension and post-retirement benefits matter, that is still pending in spite of the representation at Annexure 5 which I have given for my post-retirement
Contempt
benefits.
should have been filed, Your Lordship, in this matter. If the order was not complied fully.
It's not a matter of compliance of order.
Look at
The recommendation is there, based on the order of the coordinate bench. It is for respondent number 2 to take decision. If a time frame is made, respondent number 2
already there,
happens
Your
to be Inspector General, Deputy Inspector.
Respondent number 2 was already directed to file to pass a fresh order.
SP was, SP could have.
Respondent number 2, SP, Your Lordship.
Respondent number 2 in that case, was Superintendent of Police, could have.
Parties are present. This petition has been filed for the following reasons. The learned counsel for the petitioner submits that earlier certain order of recovery was passed against the petitioner by memo number 25 dated 8/2023, which was challenged in WPS number 2137 of 2023. The order of recovery was set aside by order dated 10 May 2023 on account of violation of principles of natural justice, and the superintendent of police collectorate building Kodarma was directed to pass a fresh order after granting an opportunity of hearing to the petitioner, and a time frame of 4 weeks was also given. The learned counsel submits that the representation was duly made by the petitioner on 10/6/2023, and subsequently a recommendation has been made by subsequently some order has been passed and the matter has been sent to present respondent number 2. The order is contained in Annexure 4 dated 24/6/2023 and all the observations made in the said order are in favor of it. The learned counsel submits that the respondent number 2 has not taken a final decision in the matter and consequently the petitioner has been deprived from the retirement benefits and other benefits and other service benefits. The learned counsel for the respondent state has submitted that the petitioner ought to have filed a contempt petition instead of filing a fresh petition. To this, the counsel for the petitioner has submitted that the earlier petition was disposed of directing the superintendent of police collectorate in Kodarma, and now the matter is pending before the present respondent number 2, and therefore the present petition. No counter affidavit as such has been filed in the present case. However, considering the nature of relief sought for by the petitioner, and also considering the fact that now the matter is pending before the respondent number 2, who has to take a final call, this court is of the considered view that the matter cannot remain pending before respondent number 2 for an indefinite period of time. Accordingly, this petition is disposed of, enabling the petitioner to oppose the respondent number 2 along with the records and a representation with all supporting documents within a period of 2 weeks per period. Upon filing of such representation, the respondent number 2 is directed to pass appropriate order in accordance with
On the recommendation.
I will not say that.
Because all the recommendation is in
We will not say that recommendation is, we cannot say that the recommendation of lower authority is binding on higher authority. In accordance with law, after by a reasoned order in accordance with law, and the reasoned order be communicated to the petitioner through speed post. This court, if the respondent number 2 has already taken a final decision, no fresh decision is required to be taken. The final decision so taken, we simply communicated to the petitioner for his records and input. This petition is accordingly disposed of. It is made clear that this court has not entered into the merits of the claim or otherwise of the petitioner, and it will be open to the respondent number 2 to pass appropriate order in accordance with law, taking into consideration all the applicable circular rules, guidelines, etc.
One observation only.
No observation.
Not regarding my post-retirement benefits, if the respondent number 2 takes any positive direction, if he takes.
If the petitioner is found entitled for any financial benefit arising out of the reasoned order, to be passed by the respondent or already passed by the respondent, the respondent number 2 shall take appropriate steps so that the financial benefit arising out of such reasoned order is also paid to the petitioner, and as well as the post-retirement benefits and other benefits is paid to the petitioner within a period of 6 months from the date of such order.
Orders with effect. Item 1, WPS 419 of 2023.
How many cases are there? First, let us see. Yes, what is
I pray for 2 weeks time.
time till March is granted to the petitioner to remove the surviving defects preemptory. If the defects are removed within time, pose this case on 11 under
This case, I'm appearing for staff selection.
Item 2, WPS 425 of 2023.
In this case, the one defect which relates to the court fee, in this case, there are three petitioners, and same
We
and
cannot exempt the court fees without any petition.
500 already been.
No, you have to pay the remaining 250 rupees के लिए कितना remove? You remove the defects within 2 weeks. Next. The same order, right? It will come on 11th March.
Item
The
3.
defects to be removed by 6th of March, preemptory order.
Item 3, WPS 472 of 2023.
क्या कहना है आपको? हाँ नमस्ते जी। आप किनको रखना चाहते हैं? सुमित्रा, you are there? तो आप उनको वकालतनामा दे दीजिए। वकालतनामा आप उनको दे दीजिए।
एक्चुअली मैम हुआ क्या है कि वकालतनामा नहीं दी है और एनओसी के लिए प्रे की हुई है, वकील से वो कर नहीं रहे हैं, वो एनओसी दे नहीं रहे हैं और 1 साल से डिफेक्ट पे लगा हुआ है और वो रिमूव भी नहीं कर रहे हैं। वो हर डेट पे उनको परेशान कर रहे हैं, इसलिए वो ये एडवोकेट चेंज करना है।
आप अपना फ्रेश वकालतनामा आ गया?
नहीं, अभी नहीं आया है।
तो आप फ्रेश वकालतनामा इनको आप आइडेंटिफाई कर रहे हैं स्क्रीन पर? किसी द पर्सन आप खुद ही हैं, आपका नाम सरिता देवी है, इनका आधार कार्ड के साथ फाइल करिए। WPS number 472 of 2023. Nobody appears. The counsel for the petitioner on record is absent. The petitioner has joined in person online and has submitted that she wants MS
Sumitra
Kumari advocate to take up her case. The matter has remained defective since filing. She suggests that she is facing some problem in getting no objection from the concerned counsel. She submits that she may be permitted to file fresh wakalat. Considering the aforesaid submission and without making any comment regarding the earlier counsel, regarding the advocate on record who is not even present before this court to represent the petitioner, this court permits the petitioner to file fresh wakalatnama. The wakalatnama should accompany a copy of that. Let the needful be done by 28 it can be done. आप कहाँ से हैं? अच्छा तो आप 13 तारीख तक वकालतनामा दे देंगे? 13 मार्च need to be done by 13th of March 2024. The defects be removed by 3rd of April. Preemptory नहीं लगे, देख लीजिए आप। Let us see what is the defect. There are lots of defects. By 3rd of April, you remove the defect. It's not a preemptory, but you remove the defects. Pose this case under appropriate heading on 8th of April.
Item 4, WPS 1146 of 2023.
Your Lordship, order dated 6th of February 2024. There was a direction to file counter, and the defect was regarding page number 41 and 42.
Have you filed your counter?
Your Lordship, direction is given to the state, Your Lordship, but I am also, my counter is ready, but inadvertently I am not filed, Your Lordship.
My counter is also ready.
The learned counsel for the respondents are permitted to file their counter affidavit during the, which is taken on record. You need to respond to that.
Yes, Your Lord.
At this, the learned counsel for the petitioner pays for and is granted time till 6th of March 24 to file a rejoinder to the counter affidavits. Two counter affidavits. Are you opposing?
Leadership, we have stated in para 8, 9 and 10 that we have made payments to the university. Now the university has to make payments.
The learned counsel is pending on behalf of the
State supplies the
respondent
copy.
state
Yes.
has submitted that the payment with regard to the existing dues of the petitioner has been debited to the
Para
university.
9 and 10, yes.
But, and now it is for the university to take appropriate steps. Post this case on 11th of March 24 under the heading of final disclosure. The learned counsel for the respondent university shall also file a supplementary affidavit with regard to the averments made by the state in its counter affidavit. The supplementary counter affidavit being filed by, we also filed by 6th of March.
Ma'am, the defect may be kindly ignored. Your Lordship.
Sorry?
The defect may be kindly ignored.
Defect is already.
It has come in the order or heading of order with defect.
With defects as such.
There must be more defects.
No, Your Lordship.
Neither legible copy of P41 and 42 of the petition has been filed. You have filed a legible copy.
They have supplied us the copy in the counter affidavit, in light of which it may be ignored, or if we are directed, we
The
can file.
surviving defect in the petition is hereby ignored.
Absolutely.
Ignore for the present. Okay, in case there is any problem, we'll see.
Item 21, WPS 5925 of 2023.
What is this IA?
Pray for not today, as our wind council
What is
Mr.
IA? IA? What is IA for?
I is for addition of some prayers.
What prayer?
For addition of quashing of ACR of from dated 1/1/23 to 15/5/23.
I oppose these laws.
Also for the parties are present, an interlocutory application has been filed being IA number 10851 of 23 for insertion of more prayers. The learned counsel for the respondents pray for and is granted time till 6th of March.
Lordship, it is a lack of knowledge, Lordship. This petition has been filed, Lordship. In the first prayers, kindly see the Lordship. In the
you
prayer,
file your counter affidavit with
not
the
already उन्हीं के IA में है Lordship कि उनका prayer already complete हो गया Lordship. In the first petition,
You said that you wanted to file a reply to the counter affidavit.
Lordship, we filed, but this case is not necessary. One IA has been allowed that requires to file counter affidavit, Lordship.
So you file your counter affidavit. If allowed.
Yes, Lordship. अगर आगे अगर allow amendment prayer add होता है, then we require counter affidavit just because his first prayer
So far as the main prayer is concerned,
वो already हो चुका है, Lordship.
The learned counsel for the opposite part, respondents has submitted that so far as the main prayer in the petition is concerned, the same does not survive anymore.
Yes.
And therefore the interlocutory application be not allowed. That is a separate cause of action.
Not as a doctor, not a separate cause of action. There is a case of the annual confidential report, Lordship. The mark is a very good and the average mark is mentioned, Lordship.
The interlocutory application relates to annual confidential report relating to subsequent period.
Yes, Lordship. When the first is claiming 1/1/2022.
That's right, we have seen that. We have seen that. And this counsel for the petitioner seeks adjournment. कब चाहिए?
After 2 weeks, as senior counsel, father died yesterday. So presently he is in
Who is
Dhanbad.
your-
Vikram Sinha. That's why I am praying for Lord.
At the request of the counsel for the petitioner, pose this case on.
After 3 weeks,
You said 2 weeks, now 3 weeks.
after calculating.
11th March?
Okay.
11th March, I will write for final disposal.
No questions.
Item 32, WPS 6320 of 2023.